So hello, Penny. Good to see you today.
Hello, hi.
Hi. Well, firstly, thank you for coming and having conversation with me. I'm sure that you're probably zoomed out after a few weeks of this lockdown. So I just would like to first introduce yourself. I will also introduce myself just in case. So my name is Sarka Wilde from Distinct Property Consultants, and I've got today Penny Stevens from Well Partnership, and I asked Penny to have conversation with us and have a little chat about the wells, the importance of well, and also some other issues that are now happening, obviously because of the coronavirus, and how to handle pretty much your well requirements. Firstly, Penny, I just wanted to ask. Because now we have a little bit more time, all of us, and it's obviously forced situation. So a lot of us are probably reviewing our affairs, and are basically catching up with the things, because will is one of those things that everybody just puts on the back burner, and a lot of times people don't feel comfortable talking to their nearest and dearest about what will happen when I die. But basically, but not doing that, they are obviously exposing their nearest and dearest to a lot of grief when
Mm.
unfortunately they pass away. So have you seen any increase in requests in for wills?
Yes, both people who haven't made wills before or thought about it and not got round to it, but also existing clients just making sure that they might have realised that there's an address that's out of date or something, or they want some updated advice. So people, like you say, are reviewing. There's a lot of life admin, I think, going on. I think where people have got the chance to reflect and sort things out, it is making people stop and think: is everything up to date? Is there anything I should do? Mm.
So certainly, it's obviously, I presume that it's also frightening at the moment for a lot of
Yeah,
people, because
yeah.
what is happening, whilst we don't want really, none of us want to face our own mortality. Sometimes people might realize, what if something happened to me and I have not protected my family? Have you had cases like that when people?
I think absolutely there is that sense of, actually, we none of us have a crystal ball and none of us know what's going to happen. And it's slightly uncertain times, and I think at uncertain times people do want some certainty.
Mhm.
And one thing they're doing is making sure what they can control, they're controlling. Mm.
Yes, yes. So, what would you suggest to anybody who might be considering whale, or they might want some update, or they just never had a whale? What would be the process? Could you just walk us a little bit through the process of whale?
Yeah, well, it depends, obviously what route they want to take. If I'm speaking to them, what I do always is offer an advice meeting, first of all, before we do anything at all, whether they've made a will before or whether they maybe something they've written a few years ago and they want to check if it's still current for them. I'll always sit down with them. Normally I would do it in person. Obviously at the moment I can't. But with online video, there's an awful lot you can do. So I'm still sitting down with people. Difference is we each have to make our own tea. But we will talk through, and we will spend maybe an hour, maybe a bit longer, looking at the whole situation. So I'll be asking lots of questions. They will no doubt have lots of questions too. But through that, we work out what the legal situation is, whether they've got something in place already or not. And from that, I can work out with them, to achieve what they're looking to achieve, what their best options are. And I always do that free of charge,
Mhm.
because because especially if people have never gone through the process before, they may not know what they even need to think about. And a lot of the time, there are things that you need to consider that aren't necessarily obvious. So
Mhm.
that would be always the first step when I do it, is to actually try and look at it very holistically and make sure we've thought of everything that needs to be thought about. And from then we can work out what people actually do need, and it might be more than one option. So then it's going through with them and working out what is the best fit for them, what fits with their priorities. And then if they then want to go and instruct me, they can. But generally, if they just want to get some advice, that's fine. But that's what I do first of all.
So basically they would come to see you, and is it quite common that people naturally then they walk away from the meeting, they come back to you with an idea of what they want in terms of their will, you draft their will, and then they may actually go away again and have second thought of, oh, I haven't thought of this, or I haven't thought of that. Do you have quite often amendments to the wills?
Well, we would cover really anything that really does need to be, unless there's something they haven't told me, I suppose, in that first meeting. But the sort of level of detail we go into, we do cover everything that we would need to. It's like, unless there's something they hadn't thought to include. But if they go on to instruct me, as we do the instructions, things would, normally come out at that stage if it hadn't been apparent when I first met with them. But the thing is, if they, later on want to change or etc., we don't charge each time they want an amendment as part of our service. So, I would encourage people to make sure those documents are up to date. So if something changes and they do need an amendment, then great. We'll sort it for them. They should always be up to date.
Yes, because sometimes, as you said, you can make the will, and then you might change the relationship. Yep. You might something happen, or one of the people that are beneficiaries of your will, maybe something happens to them. So, and it's one of those things that when you make will, you often put to the bottom drawer of your filing cabinet, and you just don't realize when we are our normal day-to-day life. So if, for example, somebody wanted to amend will now or make a new will, Penny, how do you go about signing those wills? Because naturally we are in lockdown.
Yep, because you still need, we can take instructions electronically. I can do things face-to-face with video meetings, etc. There's electronic signing. But a will itself, powers of attorney, still require a wet signature, and a will require 2 witnesses. Now, obviously, at the moment, people are having to be very careful. So we've worked with our clients to develop ways that it can be done safely, using social distancing, and it's been working really well. So there are lots of, we will guide them, talk them through it, and say, what's going to work for you, their circumstances, etc. How are they shielding, are they self-isolating, etc. But we work out a way with them that they can get it done using and making sure, because that one of the things of making sure a will is valid is that it's correctly attested, it's correctly signed and witnessed. There are other things that also go to make a will valid, but that is a really important part, and it's absolutely vital it's done correctly. So but we've also got to make sure that everyone's kept safe. So it's a challenge, but it's very doable. So it works. It just takes a bit more creative thought sometimes.
So how would you actually sign such will in these current circumstances? Is there any example that you could give?
Well, I've had clients who've done it over the garden fence, so to speak, or they've been in their conservatory and they've done over a patio table, for instance, and neighbours are coming to the garden, etc., and everyone's keeping their distance. Lots of ways you can do it, but it depends somewhat on the weather, and everybody's circumstance is going to be different too.
Yes.
But it's a talking point, it's actually turned out to be almost quite amusing sometimes when people have thought of a way they're going to do it. We've worked it all out, and they're quite pleased how it's all. It takes a bit more planning. It's maybe a bit more interesting than the regular sort of signing would be under normal circumstances. But I think clients have been through this, have found it an enjoyable challenge actually.
So something that is actually, as you said, enjoyable challenge, and something that is not that enjoyable to do. Such.
Yeah, so it's something they'll remember. That's it. So.
Okay. And so in terms of obviously when the will is signed, we know what anybody is going to inherit, etc., etc. Obviously, what would be quite, and what is of my interest, and a lot of my clients being in the property business, if, for example, somebody dies and then there is property to sell, it needs to go through probate. What are the differences in executing that with will or without will? You just perhaps explain, because that will obviously also explain the benefit of having will versus not having it.
Well, so look at this case in point where you might have property involved, for instance. Well, one key thing would be, if you make a will, you're choosing your executors, and executors are the people you appoint to make sure, essentially, that the wishes in your will are carried out. And they're the people who apply for grant of probate. And I think executors really shouldn't be underrated, and it's worth really giving good consideration as to who you would want to be your executors, because they're the people who are going to manage things for you. And if you choose a really good team of executors, there's much better chance of everything being handled much more efficiently, smoothly, and hopefully less cost to your estate, so that more essentially is passed down the line. Without a will, it's down really to who wants to put themselves forward to do this. So automatically that is one thing. But also in terms of where it's going to go, if you're making a will, obviously there are things you need to consider, but most people are choosing where they want things to go. Without a will, under the laws of intestacy, you don't have, it follows a set path. So there's a very, very set pattern as to where your assets will go. So it's not just about where things will end up, it's also the process. If you have decided who's going to you want to handle things for you. I think part of that is also it's a stressful, emotionally difficult time when someone passed away, full stop. But if there's clarity, the person who's died has written everything down, they've clearly thought about what they want, and they've made their instructions clear. I think often that's a real help to the family and people having to deal with it, because they know what they're doing is what somebody wanted. And without a will, there's that uncertainty, isn't there? Or is that what they would want? I mean, they've got to go by what the law says, but actually, is there anything that they think might have been included if such a document had been written? And the thing is, you'll never know.
Yes.
So I think it's that peace of mind of knowing that it's written down there. But logistically, it is much easier if you've got the clarity of the written instruction and you know who's going to do it. And it makes the process easier.
Yes. From that perspective, as you said, it's very hard if somebody dies for basically family to cope with their grief, and then they have to, on the top of it, be thinking what the person could have wanted. So whilst creating will and writing will, whilst we are all alive and healthy, can be seen sometimes like something that is very uncomfortable. We need to actually think that we are doing massive favor to our nearest and dearest, because at least they will have one less worry to worry about in their grief. So it's just a very sensible thing to do. And I remember when I told my parents a few years ago that I made a will, they were rather shocked of me having that conversation with them. And I'll tell them I've got no intention of dying, but you just never know what you plan one thing, but then life gives you another thing. So I think it's really, really important. Also, if, for example, somebody didn't have a will, and say you've got, for example, a lot of people these days are maybe divorced and they get married second time, and then they've got family, or they've got children from previous marriage, and things like that. How, for example, not say an example, how it would affect a spouse of the deceased if there is no will and no clear direction in terms of who will get what. And for example, the family then wanted their cut on the estate, how difficult or how easy it is for the partner of deceased to even stay in the property, because we often hear that people might need to move out because children want something from the property. Could you just a little bit talk about this?
Yeah, I mean, it can make things very awkward. For instance, you know, if again, it would, without a will, it's going to follow the lines of intestacy, and that may mean that it really doesn't follow the path that somebody would have wanted. For instance, if a couple are married but they've got children, people often assume everything would go to the surviving spouse, and the answer is it may not do. They may end up owning items, assets and property jointly with children, which could be held on trust, etc. So I think more of an issue now is also the number of couples who are cohabiting and don't have wills, assuming, I think there's a lot of assumption that this common law relationship will take care of everything, but there's no protection there. So they may have been living together for 20 years, but unless there's a will, then it may well completely, there may be no benefit to the surviving partner at all. Doesn't mean they might not have a claim against the estate, but they won't have any automatic provision under intestacy. So again, that's often even more of an issue these days.
Mm-hmm. So sorry.
So it's I think the thing is, a lot of people misunderstand where they stand legally and make assumptions based on something they think is the case, and they're often quite surprised to find that it's not. I mean, I often do sit down for an advice meeting, and it turns out where somebody thought they were is completely not where they thought they were at all, and they've just been making lots of assumptions, which are completely incorrect, and that's not uncommon. Mm-hmm. And it's understandable, because you will often see things quoted incorrectly, or they become suburban myths, if you like. That if you've lived with somebody for a year and a day, or you see all sorts of things, banded around, that there is some form of protection there, which isn't necessarily there at all. Mm-hmm. And that can be quite a shock for people. So, I've sat down. I think of somebody recently I sat down with. Literally sat down with, because this was before lockdown, and what they hadn't realised, because they weren't married, is that the way they own their property, if one of them had died, I think if sort of the first person died, they would have ended up, survivor would have ended up owning the property with the partner's parents, who they did not get on with, and that would have been a very, very sticky situation. But they didn't realise that was the case. It's now all been sorted, all documented, everything's put in place, but they just had no idea, and that would have been a really, really tricky situation. Not only did they not get on with them, but they also lived in different countries, so logistically quite tricky.
That would be very tricky, and as you said, people don't realize that. And when I'm just listening to you, I'm just thinking how difficult and how awful and how heartbreaking it must be for a surviving partner, surviving spouse or partner of somebody who is deceased, and then finding out that actually they may have lived together for 10 years, 20 years, they invested those money into that property. It's their home, and their life has been basically now torn apart by the fact that their partner died. But now they will find out that they may need to actually move out.
Yeah,
That
it
must be
depends how they
that
who
must
owned the
be-
yeah, and it depends how they own the property as well. But a lot of people don't understand about that either, and they don't realise how they technically own their property. But it's important because obviously that will influence exactly what happens in that situation. So it's important to know. I think people often either misunderstand or just have never understood the significance of knowing that answer.
Yes, yes. I think you're right. A lot of people, they don't know what is the ownership, legal ownership, whether they bought it as common tenant, or how they bought that property. And that probably will play a major part, not probably, but it will. But one other thing is that I just wanted to ask for the benefit of the listeners is just to clarify, if there is will supersedes everything. Will is when there is a will, that will, nothing goes above the will. Is that correct?
How do you mean?
I mean, for
more.
example, if there is no will, then obviously everything needs to be done by how the law dictates. If somebody creates will, then obviously that will is what we need to go by. So if somebody,
Yes.
for example, a relative challenged the will, that's, I think that's where I was heading.
Yeah, I see what you mean. Yes, in theory, but there are times when wills get challenged, and that's where it's really, really important, if there is any controversy at all, to really understand the implications of any choices you make in a will. For instance, if somebody wants to disinherit a child, they can write a will that disinherits the child, but they need to understand the likelihood and the possibilities of a claim and what that can mean. Because claims against estates, when that happens, if that happens, it makes it a very stressful and sometimes an expensive situation for the people who've got to sort it out. So it's really important to understand when one's making a will, to take proper advice and understand the implications of anything that's remotely controversial, and because it may bring risks of claims, etc. As you mentioned, it's really important to understand exactly what you're doing, and if anything is, say, likely to cause an issue, to really understand that fully. People may still decide to go ahead and do what they want to do. They just need to absolutely be be well informed about what implications that might bring later on. Yeah.
Not sure, which actually brings me to another question. Could, obviously, you as a wills expert, wills solicitor, you probably you would advise your clients. Have you ever had case or heard about case where somebody wouldn't be would have written a will, or would have had a will written, and then they actually challenged solicitor on it later because they were challenged by a family member? Because you naturally, as solicitors, you've got to be covered legally with your professional indemnity and everything like any other professional.
So again, so somebody had a will and
for example, the will was written in certain way according to the wish of a client, and say they would, for example, disinherit child or include somebody in the will. Then the will got challenged, and could there be any comeback on a solicitor? Because there is
there possibly could be. It obviously it will depend on the situation. If somebody is proposing something controversial, no doubt they will have been advised that that is the case. If they chose to go ahead on that basis, but understanding the implications, then usually in that sort of situation, everything would be documented, that this is the advice given, etc. So, but it's important. Will writing actually is an unregulated profession. There are will writers out there who are not insured, etc. It is important to actually make sure that whoever you use, that they are trained and they are carrying appropriate insurance and, you know, member of a professional body, etc. So that you can be sure the advice you get is backed up. For those sorts of reasons.
Yes. I think this is a very good advice, Penny, to mention or to let people know, to make sure whoever writes their will, it's actually a regulated professional.
At the end of the day, you can write your own will.
Yeah.
You know, so it's not regulated industry, but it's probably a bit of an unwise shortcut to write your own, really, because it may be fine, it may not, but the trouble is you won't know until it's too late. And it is very much like a will's like a parachute, except there's no safety chute. It's going to get one shot, one chance to work. That's it. And you won't know whether it's worked or not. That's the thing. You know, it's not the person who's written it. It's not the one who has to deal with the mess. So it is really important to just do it properly. It's not something to skimp on. It doesn't need to cost an arm and a leg, but it's also not something maybe to skimp on. You know, it can make it can, you know, if it's a mess, then it can cost far more to sort out than it would have cost to put right in the first place. Yeah, absolutely. Yeah.
Well, thank you. Is there anything, Penny, that I may have forgotten to ask that you are thinking that is important to mention, or do you think that we covered everything, all the basics?
Oh, it's great questions. I think it's just one of those things, like you said at the beginning, people are at home maybe a bit more, they're doing their life admin, and I think it's really important to, you know, dust out the, you know, retrieve the will from wherever you've got it, or retrieve a copy and just read through it and check, is it still up to date as far as you can tell? You know, obviously straightforward things are things like changes of address, that sort of thing, but actually has the situation changed? You know, a typical thing might be somebody now got children they didn't have when they had the will written, but there might be some life changes, asset changes, things that might have implications for inheritance tax. Lots of things to consider, and I think if you're not sure, get some advice.
Yes. So
get some advice.
If anybody who is watching our conversation, if anybody wanted to speak to you and just have a chat with you, get some information, would they be able to speak to you? Would you be happy to have conversation?
Yeah, absolutely.
How they can get in touch with you? Would you tell us your telephone number and email?
Yes, I'm on 07729 555 474, or you can go through our company website, willpartnership.co.uk, or my email is penny.stevens, that's with a PH, at willpartnership.co.uk.
Oh, thank you very much. Again, I would like to thank you for your time, Penny.
Thank you.
And I would like to wish you stay well.
And
be
you.
Positive. And I will speak to you fairly soon.